Um, and so I hope this presentation is useful for you during your preparation for the Jessup. For your information, this is the list of topics that we are going to cover. So you can see them on the screen. I want to clarify that as ever, the views that I express in this presentation are fully my own. They do not represent the views of any state or organization that is affiliated with me. In fact, as Claudia mentioned, I have developed myself in the area of the law of treaties. So I have had some experience in how the treaties operate in practice. And so I hope that this brings some clarity for those that don't, that this is their first experience dealing with the international law of treaties. And for those that are familiar with it and have a training in it, that they find this useful for your practice as lawyers in the future. So these are the topics that we're going to be addressing. And I will then begin with our introduction to the law of treaties. So the law of treaties is perhaps one of the most fascinating branches of public international law that there is. The reason for this is that treaties are everywhere, but also sometimes when we are so focused on the substance of cases or focused on the substance of your exams and other activities, you sometimes forget that they are there. Treaties are part of the normal intercourse or international relations between states. And in fact, I really like the way that Judge James Crawford refers to them in his book, in his edition of Brownlee's Principles of Public International Law. He groups treaties within the area of the law on transactions. And he puts it within the same category as the rules that govern the intercourse, the diplomatic and consular intercourse between states. And this is precisely because treaties are an essential part of how states interact with each other, and increasingly how states interact with international organizations, and even how international organizations engage with each other. This is a branch of international law that is constantly changing. And this will certainly become obvious as we go along in this presentation. So I understand that you, in one of the previous classes, you have had an introduction to the law of sources, or as sometimes they are referred to, the sources of public international law, sometimes explained in reference to Article 38, Paragraph 1 of the Statute of the International Court of Justice. So with that in mind, the law of treaty, I would say, is primarily found in customary international law. A lot of the rules that you would find regarding the conduct of negotiations, the interpretation of treaties, the application of treaties, you will find them in customary international law. But many of these rules have increasingly become codified. They have become reflected in written instruments. And perhaps the most important of this instrument, if not the most important, is the Vienna Convention on the Law of Treaties, or VCLT. As sometimes it is referred to, you can call it a treaty about treaties. So it is a very, very meta sort of instrument. It is an instrument that governs how other instruments are to be drawn up, how they enter into force, and how they operate. And in some instances, how they cease to operate. And this convention is perhaps one of the most important conventions in international law, not only because of its broad participation, I think at present it has 116 state parties, but also because, as I mentioned, it is widely regarded to be a codification of customary international law, at least in a very relevant part of it. Alongside the VCLT, which was adopted in the 23rd of May of 1969 and entered into force in the 27th of January of 1980, alongside this convention, there is another convention that you may or may not be familiar with. It is not a very famous convention. It is the VCLT-IO, as they call it. It is the Vienna Convention on the Law of Treaties between states and international organizations, and between international organizations. And so this is a convention that also governs a broad range of rules governing the law of treaties, but it is in relation to international organizations. It is important to mention that this convention has not yet entered into force. It only has, I believe, 35 states that have ratified it. And so any value that we may find in the VCLTIO, we will find it to the extent that it represents customary international law. So this is perhaps a broad overview of the rules that govern this branch of public international law. And so something that you will increasingly be aware of during this presentation is that something that characterizes the law of treaties is that it is a branch of international law that is constantly in tension. And particularly the biggest tension that you will find in the application of its rules is between the notion of the stability of the international treaty system on the one hand, and the need for flexibility in the practical application of treaties. So there are very many rules that show a tension between these two ideals. The ideal that on the one hand, treaties should be secured, they should be certain, they should give states certainty as to their obligations and their rights under international law. But at the same time, treaties are not supposed to be rigid instruments that should become obsolete with time. They should be, to some extent, able to adapt to the evolution of the law and to the evolution of facts according to the intention of the parties. So these two notions are constantly in conflict in the law of treaties. And in fact, this is something that you can find if you look at the way the Vienna Convention on the Law of Treaties was negotiated. You will find, in fact, that this is the result of the fact that, as Professor Villalpando says, and he said in his Hague Academy lectures last year, the Vienna Convention represents, in his words, a, quote, snapshot of an area of law that was in the middle of a transformation. So let's go to the moment in which the Vienna Convention was negotiated. The Vienna Convention was negotiated in a moment in which there was tension between the North and the South, because the process of decolonization was in full swing. And also there was a conflict or a tension between the East and the West, because it was right in the middle of the Cold War. And so many of the rules that you will find in the Vienna Convention and the extent to which they accept stability or flexibility is the result of strenuous and long-winded negotiations between states that had very different political but also legal interests, all of which at the time sought to be legitimately incorporated into the emerging law of treaties. In this context, we may ask ourselves, and this is something that perhaps sounds a little obvious, but you will notice that in practice, it is a very important question. And that question is, what is a treaty anyway? What is a treaty? So you will find a definition on what is a treaty within the Vienna Convention on the Law of Treaties itself. Article 2, paragraph A, or subsection A says that a treaty is an agreement between states governed by international law and which may be incorporated into a single or multiple instruments. That is the definition that is widely accepted to represent what a treaty is in international law. But you will notice that a lot of the elements of this definition really lack content. So a treaty is an agreement between states. Well, this is not true. It is true for the Vienna Convention, because the Vienna Convention only governs treaties between states. But it doesn't mean that an agreement between a state and an international organization is not a treaty. And as we said previously, the Vienna Convention on the Law of Treaties with International Organizations precisely was negotiated to cover this situation. It also says that it has to be in written form, but this is also not true. The only reason it says that it has to be in written form, in an instrument, a written instrument, is because the Vienna Convention excludes oral treaties from its scope of application. It has nothing to do with whether an oral treaty or a verbal treaty is valid or not. It simply means that the Vienna Convention's rules only refer to treaties that are in writing. Moreover, it says that it is an agreement. So here we find the central notion of what a treaty is. A treaty is an embodiment of the consent between states in the context of the 1969 Vienna Convention. A treaty is the result of the expression of consent between states, and it is only binding because it embodies that consent. And it is also an agreement governed by international law, which means that if you have an agreement that is not governed by international law, but by national law, for example, which is not uncommon, it will not be a treaty. This doesn't have anything to do with whether it is binding or not in the specific instances where this may happen. But it does mean that it is not a treaty in the vernacular use of the term. And so within this definition, you will find rather a broad range of different kinds of agreements and instruments that may or may not be treaties. So you will find, for example, in the ICJ Qatar Bahrain case, reference to minutes or declarations or memoranda of understanding are sorts of instruments that are negotiated between states or between the organs of states. For example, joint statements, interinstitutional agreements. And the question is whether these sorts of instruments should be considered treaties. This is a very important question because whether or not they are treaties determines whether or not and to what extent the Vienna Convention is applicable. And also, it also means that you should look into whether this is a treaty to determine what obligations arise under international law. So how do we distinguish between something that is a treaty and something that isn't? Unfortunately, the 1969 Vienna Convention doesn't really tell us a lot about how to distinguish this in practice. I would give you some indications of things that I have seen in my own legal practice, and this may be somewhat useful for you to sleuth around whether an instrument is a treaty or not. So in the first instance, you should look at what the parties intended. And where do we find the intention of the parties? The language of the instrument. What is the instrument called? Is it called a treaty? Or is it called a memorandum? Or is it called a declaration? This may give you some indication as to whether it is supposed to be a treaty or not. For instance, a treaty may take the form of a treaty in itself, in a stricto sensu, a convention. It could be called a protocol. And this should be an indication that perhaps we are before an instrument that is governed by the international law of treaties. You can also see the structure. So binding treaties usually have two sections. They have a preambular section or a preliminary section, which indicates what were the circumstances and intentions of the parties when drawing up the instrument. And you will find also an operative part, which is usually divided in articles. While in a non-binding instrument, you will find usually sections, parts, paragraphs, but not in essence, articles. You may also find that binding treaties will have a certain kind of terminology. For example, treaties will use the term parties. They will use imperative language such as shall, must. The treaty may also contain provisions regarding entry into force, termination, settlement of disputes. These are some indications that what you're looking at is a treaty in the correct and legal sense of the word. While sometimes you will find that in non-binding instruments that are not treaties, the parties will not refer to themselves as parties or as participants or sides. They will not use imperative language. They may say that you should do something, you may do something, you will do something, but you shall not do something. This kind of language is different in a non-binding instrument. You would also find that sometimes non-binding instruments start operating on the basis of signature, and they do not require that much formality. And they may not have dispute settlement by third parties. They may have consultations, for example. Other indications that you are before a treaty or before a non-binding instrument is the way in which it was negotiated. For example, for the adoption, authentication, and expression of consent to a treaty, usually you would have delegates that bear full powers, and we will talk about full powers later in this presentation. While full powers governed by Article 7 of the Vienna Convention on the Law of Treaties are required for certain treaty acts, they are not required for certain acts that are not related to a treaty. So sometimes these kinds of instruments will not require the state to issue full powers. And this is without prejudice to the question of the troika, or the number, a certain category of public official that doesn't need full powers, which we will address later. And finally, the subsequent acts may give you some indication. For example, according to Article 102 of the Charter of the United Nations, treaties must be registered with the UN. They have to be registered with the Secretariat. And this is necessary because if you don't register these treaties, you cannot invoke such treaties before an organ of the UN. For example, the General Assembly. You should not be, you're legally not able to cite a treaty if it is not registered, according to this article. But if it is a non-binding instrument, this rule doesn't apply because you are not required to register them. And therefore, these effects do not come into play. So one additional element that I think is very important for you to take into account is that when you look at the definition of what a treaty is, you may at first glance think, oh, an agreement between states, or an agreement between a state and an IO, an international organization, or an agreement between two or more international organizations. Well, this is very similar to a contract, you may think. And you are not wrong. But there are many rules in the Vienna Convention on the Law of Treaties which correspond in some respects to what you would find in codifications of the law of contracts in national law. But this doesn't mean that treaties are immediately subject to the same principles as contracts. And the reason I tell you that is because treaties are instruments of public law. And more specifically, they are instruments of public international law. So this means that there are certain elements that are very different from contracts. For example, treaties tend to be very formal instruments, very solemn instruments. They usually require certain formalities for them to come into effect. For example, their adoption, authentication, the issuance of full powers, signature, ratification, accession. They have depositories, which have very specific administrative functions. And this is because these instruments are intended to create formal obligation. And contracts don't usually have this level of international formality. Second, treaties are not only capable, but usually, and increasingly more usually, they are capable of regulating matters which lie beyond simple bilateral relations. They are capable of regulating matters of public concern, of public international policy, for example, human rights and the environment. And this is something that goes beyond mere bilateral relations. And you will find references to this kind of obligation, for instance, in the ICJ's Barcelona traction judgment. The court recognizes this in that case. And more controversially, and I will admit that this is a little controversial, some believe, as I do, that treaties are capable of creating objective regimes, international regimes, regimes of law that do not require the consent of a third state to become binding upon them. For example, a navigation regime, a boundary regime. These are opposable to third states, even if they are not parties to the treaty. And in fact, for example, the court has found, the ICJ has found, that boundary treaties have a specific effect, which is that they create a boundary, and the boundary survives the treaty. So the treaty has effects that go simply beyond a contractual arrangement between states. So having addressed this is very important for you to understand, because the notion that some principles of contract law don't apply to treaties is something that differentiates the VCLT from other codifications. And you should not readily and easily just transpose contract law principles to a treaty, because this may be misguided in the specific instance in which you are faced. Okay, so let's talk about a very specific topic: the capacity of a state to conclude treaties. So Article 6 of the Vienna Convention on the Law of Treaties, which is widely considered to be a reflection of customary international law, says that states have the capacity to conclude treaties. In other words, by virtue of their own statehood, they have treaty-making capacity, or jus tractatus. And so this doesn't depend on, for example, the affiliation of the state to a certain organization. It doesn't depend on the circumstance. It doesn't depend on whether you're encountering a developed or a developing state. It doesn't matter. Every single state has the capacity to make treaties. So this raises the question: what is the relationship between statehood and the capacity to treaty? So in the first instance, it is important for you to take into account that there is not a one-to-one relationship between these two concepts. It is true that all states, by virtue of their statehood, have the capacity to conclude treaties. But this doesn't mean that only states have this capacity. So Article 6 of the Vienna Convention on the Law of Treaties with International Organizations, the one that I mentioned is not in force, but this article is sometimes regarded as a reflection of custom as well. It says that an international organization has the capacity to conclude treaties if its internal organizational rules so provide. So, for example, if the convention that constituted the organization says that this organization has international legal personality, sometimes that is enough for them to be able to contract in this way. But and you will find this in practice, and if you are interested, I advise you to look into it. It is a very interesting topic. There are non-state entities that are sometimes regarded as being able to conclude treaties. And so in this context, you may ask yourself, is the mere fact that an entity signs or ratifies or accedes to a treaty a sign that it is a state? This is a very difficult question. And this is a very difficult question for a lot of reasons. And if you're interested in seeing how this kind of topic evolves, I advise you to look into the ongoing proceedings before the International Criminal Court regarding the issuance of warrants of arrest in respect of the situation in the state of Palestine, because this is something that the ICC is going to have to address at some point. And it, to be fair, it already has. In its jurisdiction decision a couple of years ago, it said that Palestine, the state of Palestine, had ratified the Rome Statute, and therefore it should be regarded as a state party to the Rome Statute. Now, in this context, there is a lot of discussion regarding these, as I mentioned, the relationship between signature, ratification, accession, and whether this is a sign of statehood. And to give you one example, and following up on the example of the state of Palestine, this is a very interesting thing, because the state of Palestine many years ago was recognized as an observer state in the UN General Assembly. And ever since then, it has been referred to as an observer state. And in its capacity as an observer state, it has signed, ratified, and acceded to multiple multilateral treaties. One of them, as I mentioned, is the Rome Statute. And so sometimes the argument is made that under one of the treaties, under one of the theories that is discussed in this context, the state of Palestine is not a state, and therefore it should not be able to accede or ratify a treaty. And the fact that it has been accepted is not necessarily a sign of statehood. And here we might look at some practice that could give you some insight as to how this question is to be ascertained. And the example of Palestine is interesting because I could ask you the question: if you are before an entity that a wide majority of the international community considers a state, but there's another group of states that doesn't, and this is a fraught question for some, then what happens when that entity signs, ratifies, or accedes to a treaty? What happens then? And so who is competent to make a determination regarding whether such an instrument of ratification or accession is valid? Is the depositary of the treaty competent to make such a determination? This is a complex question because depositaries under the law of treaties have an administrative function. They don't have an adjudicative function. And they do have legal advisors. These legal advisors contribute to the question of whether certain instruments are valid. But the depositary itself doesn't have this kind of function. And so in the practice of the UN, for example, the Secretariat usually looks at what the practice of the General Assembly is. If the General Assembly considers a state to be a state, then the Secretariat will follow this practice. And so when the State of Palestine deposited its instrument of accession of the Constitution of UNESCO, the UN Secretariat looked at whether the State of Palestine was a state for the General Assembly. And it so happened that months before that, the Assembly had adopted a resolution stating that Palestine was an observer state. So regardless of whether it was a member or not, the Secretariat said, well, the Assembly calls it a state, and therefore I will call it a state. And it accepted this. And this has happened multiple times. And so this is a question that leads to a lot of discussion. And if you're interested, I can share, after this presentation, I can share some academic discussions on the topic. Regardless of whether you hold one opinion or the other, it is definitely a very fascinating academic question. So I mentioned before the question of full powers. So full powers. Does anyone here know what full powers are? I don't know if anyone is willing to venture a guess in this respect. You can just call out and answer the question. Otherwise, I'll do it. Anyone? Full powers. And you will not find the definition in Article 7 of the Vienna Convention, by the way, in case you're looking it up. It is elsewhere, but it's not in Article 7. No brave person? Yes, Libby. Go ahead.
Okay, a title to that would be, I would say full powers is power given to either the president or, for example, a foreign minister, in that whatever he does constitutes the position of a state.
So interesting, because if you look at Article 7, in the structure of Article 7 of the Vienna Convention, and thank you, Livy, I hope I'm pronouncing your name right. Thank you for your courage. If you look at the structure of Article 7, you will find that it indicates that there is a need or there is a practice of issuing full powers. And then there are some public officials within the structure of the state that do not require to produce full powers. And so your first instinct when seeing full powers and seeing terms like plenipotentiary, for example, you would think that full powers are a capacity, a kind of ability or function, but they are not. According to Article 2 of the Vienna Convention, full powers are a document. They are a document. And if you look up what full powers are, you might actually find models of full powers or even actual full powers. They are instruments, they are documents. And these documents confer upon public officials the representation of the state for the purposes of certain treaty acts. That is their purpose. And so these treaty acts may be the adoption of a treaty, they may be the authentication of a treaty, or they may even be the expression of consent for a state to be bound to a treaty. And so this is something that the instrument itself will tell you. And what Article 7 says is that there are certain public officials which, by the inherent nature of their function within the state, they do not need to produce full powers to prove that they are representing the state, because they represent their state by the mere nature of their functions. And this is referred to as the Troika, or the Big Three. Very, very legendary references there. The Troika or Big Three, and Big Three, sorry. And these are the, I believe Levy mentioned them. They are the head of state, the head of government, and the Minister for Foreign Affairs. These three public officials have the capacity, their inherent capacity, to bind the state. And so they have what in the doctrine is called the jus omnimode representationis, the capacity or the right to represent in any way the state. Now, I will not delve into how this capacity is exercised and how this capacity is conferred upon a public official, but I will tell you that there are certain discussions regarding other public officials which are not part of the Troika that may, in some instances, represent the state for certain actions. And so the general rule in that respect for public officials that do not belong to the Troika is that they need to have full powers. There are two exceptions to this. The first exception is the ambassador, the head of a diplomatic mission. The head of a diplomatic mission doesn't require full powers for the purposes of authenticating and adopting a treaty, but they would need full powers to express consent. And there is a question, and this is mentioned in, I believe it's in Article 7, 1b of the Vienna Convention, that there are certain public officials that, given the practice between the states and the way in which the negotiations were conducted, that they are deemed to have this capacity inherent in them, even if they are not part of the Troika or they do not produce full powers. And the way in which this has been analyzed in other cases is that sometimes, this is something that has to be analyzed on a case-by-case basis, sometimes public officials which are entrusted with a certain state function, for example, the ministers that are in charge of a certain portfolio, may have the capacity to bind the state in practice with regards to the portfolio which they have been entrusted. So, for example, a minister of the environment may, in some situations, have the capacity to bind the state with regards to instruments regarding environmental law. But this is something that has to be analyzed on a case-by-case basis. It is not a general rule, and it has not been accepted as a general rule as widespread as it is the case, for instance, for the Troika. But Article 7 is very, very useful in practice, because if you want to determine whether an instrument of accession or a signature or an instrument of ratification is valid on account of who presented it, then you will have to look at whether that person is in fact empowered in accordance with Article 7 of the Vienna Convention to deposit such an instrument, to express consenting number in the name of the state. And so if a person signs a convention, but that person is not part of the Troika, is not a person empowered by a document of full powers, then it is very likely that this signature should not have international effects in that instance. Now, what happens with international organizations? Well, as I mentioned, the VCLT-IO is not in force. But even if it were in force, it is not clear in Article 7 of the VCLT-IO who represents an international organization. So in practice, the international organization should, in basically every respect, produce full powers. Because there is not a clear rule in customary international law as to whether the chief executive of an international organization has the capacity to bind the organization in every respect. This is something that is in the process of evolving, and the VCLT-IO only represents, as I mentioned, a snapshot of the law as it stood in 1978. So not an easy question to answer. And perhaps it's a little my fault, because the way this presentation is built up is it is built around issues that would help you in your practice, but they are not so easily solved in practice. So they should be regarded as food for thought for you to look into this topic more thoroughly. So that disposes of the question of full powers. I will now teach you about a topic that is fascinating. It is absolutely fascinating. So what happens when a state signs a treaty and has not ratified that signature? So the treaty is not in force for that state. So if the treaty is not in force for that state, the state does not have international obligations arising out of the treaty. And this is a very difficult thing because sometimes there are situations in which states conduct certain acts that undermine the operation of certain treaties after they have signed them. Or for example, after they have expressed consent in accordance with the treaty, but the treaty is not yet in force. And so Article 18 says, Article 18 of the Vienna Convention on the Law of Treaties, 1969, says that states have an obligation under the Vienna Convention, and this is regarded to be customary international law as well. They have a duty not to defeat the object and purpose of a treaty while its entry into force is pending. So after they sign the treaty and before they have ratified it, or after they have expressed consent, for instance, ratifying, acceding, etc., and before the entry into force. So that's it is a rather abstract notion, very abstract notion. And so what defeats a treaty's object and purpose in practice? It cannot be just any action. It really couldn't, because otherwise you would be equating the obligation not to defeat the object and purpose of the treaty with the obligations that emanate from the treaty. And if the treaty is not yet in force, there is no provision of international law that allows you to bypass the state's sovereignty in this respect. If the treaty is not in force, the state doesn't have the obligation under the treaty. So you cannot simply ask the state to perform the treaty before it is in force. You have to wait. And so in the doctrine, this is very hotly debated. What defeats the object and purpose of the treaty? And it is not very clear, because to my knowledge, the question of defeating the object and purpose has not yet come before an adjudicative body. There is no unified criterion on what violates this duty. In this context, there is a discussion that is sometimes made regarding the actions of certain states that have withdrawn signatures. And to my knowledge, the first state that did that was the United States, but I have knowledge of many other states that have done that. And so the question is, are states entitled to withdraw signatures? Well, again, a very difficult question. So the concept of withdrawing a signature is not regulated in the Vienna Convention. So in principle, once you sign it, you have signed it. However, the duty not to defeat the object and purpose of the treaty does have very important exceptions. And one of those exceptions is when the state has made known its intention not to become party to the treaty. From the moment in which the state is clear that it will not become party to the treaty, even if it has signed it, then the duty not to defeat the object and purpose of the treaty ceases to operate in respect of that state and in respect of that treaty. And so you could make the argument that the practice of withdrawing signatures or notifying the withdrawal of signatures may, in some instances, fall within this exception. But this is not something that is settled in the literature. So, there's a lot of food for thought there if you want to look into it. All right, so application of treaties. The application of treaties is a very broad topic. You will find very many provisions of the Vienna Convention on the Law of Treaties which govern the application of treaties. And perhaps the most important rule in this respect is Article 26 of the Vienna Convention on the Law of Treaties, which embodies the principle of pacta sunt servanda. And the principle of pacta sunt servanda is widely regarded, in fact, almost unanimously regarded to be a principle of customary international law. Does anyone know what pacta sunt servanda means? What is pacta sunt servanda? And once again, anyone can answer. It is open to anyone that wants to venture a guess.
Hello, sir. Pacta sunt servanda means the treaty must be followed. It cannot be violated.
Excellent. So exactly. And thank you for your answer. So the principle of pacta sunt servanda, it comes from a Latin phrase which says that treaties are to be observed, or pacts or agreements are to be observed. And this principle, by the way, also exists for contracts in very many instances of national law. But in international law, this is a well-established principle that once you have expressed your consent to a treaty in the manner in which the treaty so provides, and the treaty has entered into force, you are under a legal obligation to perform the obligations which are established by the treaty. You have to perform them. And if you do not perform them, then you are in violation of the treaty. And I understand that you have already had a class regarding international responsibility. So you know exactly the consequences of not performing a treaty. Once again, this is a different body of law, so I will not once again delve into it. But you know, the notion would be that the treaty is the primary norm. And when you fail to perform the primary norm, then there are some secondary norms which come into operation and dictate the consequences of the internationally wrongful act. So this is very basic concept, very important. And related to this provision is a provision of Article 27 of the Vienna Convention on the Law of Treaties, which provides that the provisions of national law of a state cannot be used as a justification for the failure to perform a treaty. So a state cannot say, my internal law forbids me from performing this treaty which is enforced, because once it is enforced in accordance with international law, and the state has consented to the treaty in the way in which international law so provides, the state cannot fail to perform the treaty. Any attempt or intent to fail to perform the treaty would be a wrongful act, which would trigger the state's international responsibility. And so what happens with internal law? Internal law is, it is, as its name indicates, it is law for the purposes of the state, but it is not law for the purposes of international law. If you're interested in looking into this topic, once again, you can send me an email. I will show you my email later on, and you know, I can share you some papers and academic materials on this. But for international law, the provisions of internal law are facts. They are not provisions of law. They are facts. They are acts of the state which evidence the will of the state, but they are not legal provisions which provide an exception to the treaty. And so if the state says that its internal law says that it cannot, in this instance, perform this obligation, well, too bad. It will not perform it, but it doesn't mean that this state is excused from its responsibility to perform the treaty. So has anyone ever heard an exception to this principle? Because there are exceptions to this principle. Anyone care to venture a guess as to an exception to this principle? Anyone has heard an example of an instance in which the internal law of a state may be an exception? Because there are. Daniela, go ahead.
Yes, I knew that some exceptions could be the illegality as well as a change of circumstances and force majeure.
Okay, so yes, and thank you for the answer. The Vienna Convention on the Law of Treaties, and we will talk about this in a different slide, but it does have certain instances in which the treaty can be terminated or its operation may be suspended. So it is true, and some of them are the ones that Daniela mentioned. For instance, a change of circumstances, fulfilling the requirements of Article 62 of the Vienna Convention. But there is an exception. There are actually two exceptions that I would like to mention for Article 27 itself. Article 27, which provides that you cannot invoke internal law as a justification for a failure to perform a treaty, mentions that it is without prejudice to Article 46 of the Vienna Convention on the Law of Treaties. And this is where the answer that Daniela gave us rings a bell, because Article 46 of the Vienna Convention on the Law of Treaties governs a situation in which a treaty is invalid because it contradicted fundamental norms of internal law of a state. But this is so long as these norms are publicly known to the other party that signed the treaty, and also they are of a fundamental nature. They're so fundamental that it is evident, it is manifest that there is a violation and that the state should not be held to the treaty. But the state has to invoke this. It doesn't operate automatically. The state has to invoke this circumstance, and it has to be proven that it was a fundamental norm, that the violation was manifest and clear, and that the norm itself was publicly known or it was known to the other party, because otherwise, pacta sunt servanda applies. The second exception is where the treaty itself says that it is subject to internal law. So, for example, very many environmental treaties say you have this obligation, but this is subject to internal law. Or, for example, transnational criminal law provisions, for instance, in the UN Convention on Transnational Organized Crime, some provisions say you have the duty to, for example, extradite a fugitive, but this is subject to the provisions of your internal law in some instances. So here you can invoke internal law so long as there is a renvoi from the treaty into the internal law. Otherwise, you cannot do it. So there are certain instances in which a treaty is capable of operating in respect of third states. I will not go into detail with this because this is a very ample topic. But there are basically circumstances in which a state creates obligations for a third state, and a treaty creates rights to a third state. But in both instances, you need to be able to establish the consent of the third state. And in the instances in which you can find that consent, then in the doctrine, it is considered that there is an ancillary agreement between the parties to the treaty and the third state in respect of the performance of the obligation or in respect of the exercise of the right. But this is not an automatic consequence. Treaties usually do not create obligations for third states. They do not automatically confer rights on third states. There has to be consent as a general rule. Now, an important topic, treaty interpretation. Treaty interpretation, you'll find the general rule of interpretation in Article 31 of the Vienna Convention, and this is complemented by Article 32. Very important topic, very important. And you have to know that every single exercise of trying to identify the meaning of a provision of a treaty is interpretation. So it is not only adjudicative bodies like the ICJ that interpret treaties. States also interpret treaties. And in fact, states are the authentic interpreters of a treaty. And this is also recognized by Article 31 itself. It says that the subsequent practice of states or subsequent agreements of states regarding the interpretation of the treaty are a factor to take into account in giving meaning to the terms of the treaty. And what is the general rule? Well, the general rule, according to Article 31(1) of the Vienna Convention, is that the terms of a treaty shall be interpreted in good faith, in accordance with the ordinary meaning of its terms, in context, and in light of its object and purpose. I will not go into detail into each of those elements, but you will find them in the jurisprudence of the ICJ. And what you have to know is that these are not separate elements. It's not that they are elements of interpretation or methods of interpretation. It's not that you first interpret in good faith, then according to the terms, then according to the context, and then according to the object and purpose. No, it is rather a holistic norm. It is a holistic general rule of interpretation. You have to take into account all of these elements in order for you to ascertain the meaning of a term. And you will find that this is a very objective exercise because you have to look at the ordinary meaning of the word that is found in the treaty. And this is based on the notion that the way the treaty was drawn up, the way in which it was written by the parties, is an authentic indication of what the treaty means. You cannot ignore the literal meaning of terms in order to safeguard an unexpressed or secret or private intention of a party. You have to look at the terms of the treaty always. And only when an interpretation under Article 31 is obscure or it is absurd or you want to confirm it, then you look at the preparatory works of the treaty and look at what the intention of the parties was. And that is called the travaux préparatoires, and that is what is provided under Article 32A of the Vienna Convention. So that is interpretation. Reservations. Reservations are a very broad topic. I'm not going to go into a lot of detail into them. So does anyone know what a reservation is? Anyone want to venture a guess of what is the concept of reservation?
Mary?
Let's see, I have a hand. Yeah, go ahead.
So I think the reservation is when the state makes certain reservation in terms of certain provision in the treaty so that it will not be applicable to this government exactly. However, it must not go to the root of the treaty itself. For example, in some treaties like for the prevention of genocide or crimes for some other peremptory norms, they don't usually allow reservations because that goes to the roots of the treaty itself.
Very good. So a reservation, and thank you for the answer. A reservation is a unilateral declaration. It is a unilateral statement. It is deposited by a state at certain moments of treaty creation. And the state says, I want to modify or exclude the application of a certain provision of the treaty. The general rule is that reservations are allowed. However, there are exceptions, there are limitations to this. One of the limitations was mentioned by our colleague, which is that they are not able to formulate reservations in respect of provisions or in a manner in which the object and purpose of the treaty may be undermined. So you have to respect, as our colleague said, the root of the treaty. You have to respect the reason of the treaty, the reason why the treaty was made. And so this rule actually was not universal all the time. This rule was recognized by the ICJ in 1951 in its Genocide Convention Advisory Opinion. And this represented an inflection point, because before that, there was very little flexibility for reservations, very little. The principle that was recognized was the principle of integrity of the treaty. The treaty should be kept integral. It should not be separated. The application of treaties should not be subjective to which party has signed or ratified it, but it applies as a single undertaking to everyone. But the ICJ in the 1951 advisory opinion said, this is not quite true. So yes, treaties are integral, but there is a practice of reservations. Reservations are allowed so long as you don't undermine the object and purpose of the treaty. And this is the understanding that you will find in the Vienna Convention. So there are some topics here that go into some depth as to the practice of reservations. I will not address them, but if you want to have some materials on it, I would be happy to share them, so long as they are not affecting the topics of this year's Jessup problem. Let's see, we have the concept of termination, suspension, and invalidity. And I really like the way in which Professor Villalpando calls them. He calls them the black holes of treaty law. The reason why they are called the black holes of treaty law is because they are really not very common in practice. They very rarely come up. Perhaps the ones that come more usually are the provisions on termination, some of them, but it's not very common. For example, the provisions on of denunciation of treaties. You may find some of that in practice, but they are not very common. In fact, in the rules on invalidity of treaties, I personally have never seen a case of invalidity. I have seen cases in which the topic of invalidity has come up, but they are not very common provisions. And this is because precisely in the Vienna Convention on the Law of Treaties, the provisions regarding invalidity of treaties are very complex. They are very detailed. And in many respects, they were not part of customary international law at the time in which the Vienna Convention was drawn up. They were progressive developments of the International Law Commission. Some of them, of course. Some of them were codifications of custom. For example, some consider that Article 62 of the Vienna Convention, which governs fundamental change of circumstances, is not a progressive development, but rather a part of custom. This is hotly debated, but there is evidence to say that it might have been. It might have been a part of custom before the Vienna Convention, but it is certainly part of conventional law now because of the Vienna Convention. And so what is to be made of the fact that invalidity of treaties is not very observed in practice? Well, perhaps you would say it is a good sign. It is a good thing because it means that the validity, the operation of treaties is not usually impugned by states. States usually invoke other exceptions to the application of treaties, perhaps exceptions that are built into the treaty, or perhaps exceptions that are found in customary international law. But you really don't find much practice regarding invalidity. It's an interesting topic, but it's in practical terms, they do not have that much of an implication, which is a shame because of the way they are so complex and detailed. They would be very fascinating if there were a lot of practice. But it's a good thing from a practical perspective, a shame from an academic perspective. But in essence, this means that in reference to the rules on termination, suspension, and invalidity, there seems to be some indication that states really value the stability of the treaty system. They value the certainty that comes with treaties. And so they are not very quick to impugn this validity. So, and to conclude the thought part of this presentation, what is the future of the treaty regime? So it's actually very difficult to say. It's very difficult to say because for a long time, treaties were not very common. Treaties were not the main source of international law for a long time. In fact, for a long time, customary international law was the main source of international law, although, the law of sources was not as definite. In the 19th century, 18th century, you will find very interesting philosophical questions regarding what the origin of the law is. You will find it in reference to positive law and natural law, but usually custom. Treaties they're not a new thing, but their proliferation is something of a new development. They started to become very used in practice in the last century. And now it appears that they, once again, are in some sort of decline. And I would like to qualify that because they are in decline in the sense that there is an emergence, a very recent emergence of new forms of quote unquote international transactions. So as I mentioned before, you have joint declarations, you have memoranda of understanding, have non-binding arrangements, interinstitutional agreements that are more informal, they're more quick to come into effect. They foster the confidence between nations in a very different way than treaties do. This by no means signifies a decline in the sense that treaties are starting to lose importance. Rather, I would say that treaties are starting to lose their monopoly as sources of international law. The law is starting to change a little bit. And in fact, you will see in the agenda of the International Law Commission that now there is a question as to non-binding international agreements and arrangements. And this is something that I would advise that you look very deeply into, because I think that this would play a very important role in the future. What is the role of non-binding, non-treaty arrangements between states, which are perhaps not formally binding in the sense that treaties are, but which do create political or perhaps social or even moral arrangements for states. And so you will find that soft law starting to gain a lot of traction in this respect. And this, the second qualification that I would make is that even though treaties are a little in decline, they are multiplying. And it is a very paradoxical. They are losing their monopoly, but at the same time, they are starting to be concluded en masse, So, and they're also starting to diversify a lot. You have a lot of very specific treaties. For example, just last year, there was a treaty adopted in the UN, which is sometimes called the BVNJ agreement, or the agreement regarding the conservation and sustainable use of biological diversity beyond national jurisdiction. That is the name of the agreement. It is an ancillary agreement to the UN Convention on the Law of the Sea, and it is very specific, very specific. And it is a very new treaty, very innovative, very interesting, and it was negotiated for around 14 years in the UN. So treaties are propping up. They are multiplying. They are diversifying, but at the same time they're losing their monopoly. And also, treaties are adapting. So I really like the concept once again of Professor Villalpando, and I would advise that you look into his writing in respect of the evolution of the treaty regime, because he says that modernity is liquid. Modernity changes. Modernity adapts. Things change. Things are changing all the time. You might have noticed that. It seems like every day something world-shattering happens, but it also changes in very small things. And this liquid modernity, this changing of modernity, forces treaties to adapt. And you will start to see that in order for treaties to maintain their relevance, some things are starting to change as well. For example, I have a list here that I will say to you that maybe you will find interesting. For example, you have treaties that create international organizations and institutions. And so these institutions are starting to develop mechanisms capable of creating derivative law. For example, policies to interpret the instrument, policies to apply the instrument. Imagine, I think it was last year that the UN adopted a system-wide UN water strategy. This is an application this is not for states quite, but it is rather for its own organs as to how priorities related to water should be consolidated. They should be coordinated between UN agencies, etc. And so this is a derivative instrument that governs the policy of water for the UN. And this is, an evidence that there are institutional mechanisms that create derivative ways of adapting treaties to modernity. You also find that there are institutions or institutional mechanisms for implementation. This is very common, for example, in human rights treaties, which create human rights bodies in courts and tribunals, but also environmental treaties, which establish non-adversarial mechanisms of consultation and dispute settlement. They have their own way of institutionalizing the implementation of treaties. You find that new rules on how treaties should be interpreted are arising, for example, in the field of human rights. You find that more and more treaties are starting to become more, there is a tendency for treaty language to become more convoluted and complicated so as to accommodate more and more diversified views between states. And this is an evolution that allows the treaty regime to be fortified, but also to be flexible in a way. You find opt-in and opt-out mechanisms, reservation mechanisms that are starting to gain tractions. And treaties are starting to become constructively ambiguous, is what the doctrine says. They become more ambiguous so as to encompass a broader range of obligations. And you will find, especially in fields like human rights and environmental law, an entanglement between binding and non-binding provisions, which is something that also gives flexibility to states. So I would say that the treaty regime has a future, but it will be a very different future from what you see in the Vienna Convention on the Law of Treaties. And the Vienna Convention on the Law of Treaties itself really paved the way for this, because, as I mentioned, it values stability, but it also values flexibility.